rise. The Court of Appeals, Division 1 is now in session.
Please be seated. Good morning. We are here for oral argument in case number CV21-0478, Fadley versus Encompass Health, Valley of the Sun Rehabilitation Hospital. Each side has 25 minutes for arguments today, so 5 extra minutes for the last word. And Mr. Workin, as you know, you can reserve time for rebuttal. Just keep that. It's like you're here so often, I feel I could just say, let's start. But proceedings are being audio and video recorded. Please introduce yourself when you start. We've read the briefs, and with that, let's begin.
Thank you, Your Honors. May it please the Court, I'm Charles Workin, and I represent the defendant appellant Encompass, and I intend to, hopefully, reserve 5 minutes for rebuttal. As the trial court recognized in its conclusion of law number 19, APSA liability is not vicarious, unlike agency liability. To be liable under the APSA statute, a defendant must have caused or permitted an injury. Here, the trial court found that Encompass did not cause Mrs. Fadley's injury. Nevertheless, the trial court found that Encompass is liable under APSA by finding her doctors, Barnes and Patel, who are the injury-causing persons in this case, to be part of the Encompass enterprise. And admittedly, as we did below, Encompass is an enterprise. It is a corporate entity that is involved in the business, if you will, of providing care to persons and, in this case, to a vulnerable adult, Ms. Fadley. But we argue that the doctors cannot be part of the Encompass enterprise for 2 reasons. First of all, they are exempt from APSA liability. Neither of them was a medical doctor.
So counsel, do you see any difference between the word liability and, I guess, what has been ordered here, which from Judge McKittish, which I think is Encompass is liable? Do you see that distinction?
Well, Encompass, it cannot be directly liable. It did not cause any harm or...
Right, no, focusing on your first argument.
Yes.
Which is the word liability, and I'm not sure which year the statute was amended, but to exempt physicians from liability. Did Judge McKittish's order hold those physicians liable?
Well, he did not hold them liable. By the way, I think the statute was amended in 2003 in the manner in which you're referring. They were not named as defendants in this case. So he did not find them to be liable, but he did find that they had committed acts of abuse or neglect.
Okay, and does the statute say they can't, their actions are irrelevant for purposes of the statute, or is it just, again, liability?
Well, their actions are not irrelevant in the sense that Mrs. Fadley could have sued them. They are each persons, and persons, an individual person can be liable under the APSA statute. And, maybe we might imagine that the 2 of them also were a group of persons that were involved in providing care, and that the 2 of them were an enterprise. But they are exempt. And, had they been sued, I believe that they could not be found liable. They have a defense because neither of them was a medical director and neither of them was providing services at one of the facilities where
could
is
they
a prerequisite to being liable.
Let's talk about that enterprise. finding in the definition of enterprise, which includes a person or any group of persons.
Yes.
And Arizona's legislature has generally defined person to include corporations.
Indeed.
So isn't it possible that Encompass and these two individual persons are three persons that are a group of persons that is an enterprise?
Yeah, well, the definition of enterprise there seem to be two definitions there. One is an enterprise can be, just in short, a legal entity, which is what Encompass is, so therefore it's an enterprise. Or it can be a group of persons. And wherever it is, Title II, the definition of person can include a legal entity. So, I suppose that a legal entity could combine with a natural person to form an enterprise. It seems to be redundant. There's an overlap there, but how does a legal enterprise like Encompass form a enterprise with an exempt doctor and then become liable for that doctor's conduct?
Isn't that by undertaking to be associated in fact? I mean, it's like, I read that definition and it says if you are associated in fact to provide care for a vulnerable adult. So because really the cause of action is for abuse or neglect, either committing the abuse or neglect or permitting it.
Yes.
Right? So permitting it is also part of that in the care of a vulnerable adult. So if two persons come together and together provide care for a vulnerable adult, are they not associated in fact and therefore in an enterprise?
The two persons in your hypothetical would be?
It would three persons in this case.
Well,
it would be Encompass and then Doctors Patel and...
But then we still get to before we get to the definition, although, the definition is necessarily, has to be read in the context of subsection B of the statute, a person or enterprise can be liable if it has caused or permitted such conduct. But so here again, Encompass didn't cause or permit anything.
But Encompass plus those two individuals did. Or at least those two individuals did, and if they are combined with Encompass as an enterprise, then an element of the enterprise caused the liability, right?
Well, it is my argument that that Encompass cannot be associated in fact with a doctor who is exempt, and also cannot be associated in fact with a doctor that has been acknowledged to be independent of the hospital. And I'm now referring to the conditions of admission that were signed by Mrs. Fadley.
Well, I mean, so I didn't see you make this argument, but are you saying that an enterprise, when you sue an enterprise, you have to sue all its members? And here you can't sue two of the members, or you can, but you just can't recover any damages and you get thrown on 12b-6 because there's an exemption?
Well, because this isn't a vicarious liability situation. There has to be, if you are associated in some way, or if you exist in such a way that you constitute an enterprise, fine, that's step one perhaps. But step two is that you have to have caused or permitted some injury. And, here we have an express finding that Encompass did not cause any injury. Well, and permitting injury, I think, is not on the table here.
What if we move, so I think like an economist, upstream, and we first define enterprise? Isn't that the lens through which we review issues like you're raising, which is we didn't do this or we did do this? It's the definition of we, or here enterprise. And so at the outset, if enterprise includes Doctors Patel, Barnes, and Encompass, why can't that pronoun sort of carry forward, but in a collective meaning?
Well, then let's assume that that could be if you had doctors who were subject to liability and doctors who had not been acknowledged to be independent. And those are two different arguments, but let's take the first of them. Let's assume that Doctors Barnes and Patel, that one of them was a medical director or that one of them was a primary provider in one of the listed facilities, that Encompass was a listed facility. So, then you have an enterprise of Encompass with a doctor who is subject to liability, and the doctor engages in some conduct that's abusive or neglectful and causes an injury, gives rise to liability. Then you have an enterprise that's subject to liability, and now we get back to, can the other member of the enterprise who did nothing except by some legal definition or collection of circumstances become part of the enterprise, is that legal entity also liable?
Well, it's interesting you say nothing, because this statute uses the word permit, right? So here it says, having caused or permitted such conduct. What is that?
Well, I think that contemplates a situation where one is observing abuse or neglect to occur and does nothing about it, and you permit it to occur. I think.
Where do you draw the observational requirement? I mean, to me, it would seem broader than that. Perhaps setting up circumstances which would allow for the abuse or neglect to occur, policies and procedures that lead to that kind of thing, like permitting. I'm not sure what requires somebody from the other part of the entity to actually be present and observing. Is that what you meant, or maybe I'm misunderstanding?
Well, that would be one example, or having knowledge of it, even if you weren't present and observing the abuse or neglect, but you learned of it and you let it go on. There is a requirement in another of the statutes in the Act about imposing a duty to report abuse, neglect, exploitation to law enforcement. So, the mere fact that Encompass has these doctors on staff doesn't mean that it permitted them to do something that was abusive and neglectful. And permitted has not been at issue in this case.
Yeah, and I apologize for getting off that track, because I really do think we need to focus on enterprise as the lens through which, right? Because if enterprise includes all three, then cause or permitted, you're okay. But let me ask you, so APSA is a statutory cause of action, right?
Yes.
And it has a criminal component, is that right?
It does.
Who is liable or can be charged under that statute? Is it just person or person enterprise, or who is identified, like we're talking here, civil action, it says person or enterprise. So let me say, I think it's person. So that's okay, Mr. Workin. I'll go back and try to make it clear. Can you, on this independent sort of, consent and conditions argument, which is explaining up front that there's a hard stop between independent doctor and institution, can you do that, you think, for criminal liability?
Your Honor, I have not thought about the criminal aspects of this statute at all in these past many months with this case.
I appreciate that, Your Honor. That's fine. And it's unfair for me to ask that because, it's just sort of, but I appreciate that.
I don't want to spitball and make something up.
Do you know of any criminal statutes that require some sort of collective in order to trigger, that you can sort of disclaim any sort of, liability. I know that's not, whatever the equivalent is in criminal law, exposure.
It's been a long time since I prosecuted or defended. What comes to mind perhaps is conspiracy, which is an agreement between two or more persons to commit an unlawful act, and then one of them commits an overt act in furtherance of the conspiracy, and then they all become liable for the crime of conspiracy. Beyond that, are they all liable if the conspiracy goes to conclusion and commits the ultimate criminal act?
I think what Judge Weinsweig is getting at, in that circumstance, can you're together in your back room coming up with your criminal conspiracy, but before you go off to engage in it, or perhaps before the discussion, you have everybody sign the waiver, the disclaimer. Can you disclaim your participation in the conspiracy?
It is possible under Arizona's conspiracy statutes to withdraw from a conspiracy.
Okay.
And there are some bases you have to touch to do that. I remember that much.
Okay.
All right?
Well, perhaps easier back over in the civil realm that we're playing in today. Can you disclaim a fact? And I think that's what we're getting at here. If these two individuals are indeed definitionally a part of the enterprise, can you somehow get somebody to sign that away through this type of disclaimer?
Yes, and my friend Mr. Bodney argues in his supplemental brief that you can't disclaim a fact. Facts are facts. Facts are stubborn things. I love that quote. But, here we have this condition of admission signed before anything went wrong, and she acknowledges that the doctors are independent. That's, a disclaimer, and I think it creates that separation between Encompass and the doctors, and she's acknowledging that they are not associated in fact in providing her care, that they are independent in doing so, exercising their own medical judgment, et cetera.
Mr. Workin, I think I sense like a blending here of those two concepts. So I can see how you can say, hey, look, these are independent docs, right? They do their own billing, they do their own practice, they exercise their own judgment, so they're not our agent. Okay, but that to me seems to be a different question than whether or not they're associated in fact in providing care for a vulnerable adult. That seems like it's a different question entirely.
I don't think it is, and I think you're begging the question of what does it mean to be associated in fact. And, if you look at this superficially, without considering the consent to admission, they look like they're all associated in fact, but we have here a disclaimer. Let me pose a hypothetical. Let's suppose that, that Mrs. Fadley was transported from Encompass to go to her doctor's follow-up visit with Dr. Chang. And I'm assuming she was put in an ambulance or some sort of medical transport. Let's assume that the ambulance workers who they have an independent company. They're not employees of Encompass. And that they drop her from the gurney, or they drop the gurney suddenly to the ground and they cause her injury. Now, one could argue that they are also part of this group of people, entities, what have you, that they're an enterprise involved in providing care. Now, if they drop her, is Encompass going to be liable for that? Or another hypothetical, which I understand can occur, someone who shouldn't get out of bed, hospitals understaffed, the family says we want to hire an independent sitter to sit in the room and watch our mother so that she doesn't get out of bed without her brace on, something of that sort. But that sitter falls asleep in the chair, and Mrs. Fadley gets up and falls. Or that person goes to the bathroom for a minute, Mrs. Fadley gets up and falls. Now, Is that person also part of the enterprise providing care, and is Encompass now liable in that situation? There has to be some limit. You just can't sweep every person who's involved in the provision of care into the enterprise and make them liable for things they didn't do.
And I appreciate that, and maybe you should be over here asking, because we're supposed to pose the hypotheticals, right? But here we have two doctors, independent, so I appreciate the consequences, is I guess what you're saying, of an expansive definition of enterprise, but I don't think that's what necessarily we have to decide here. Maybe keep it in mind. We're almost at 5 minutes. Let's talk about the medical bills issue.
Yes.
Let's say we agree with you. What is the right thing to, what does an appellate court do in that instance?
Well, in this case, you have the facts here to do the math. So you could take the medicals that are set forth in the findings and conclusions, and you can subtract that amount, or you can subtract half that amount from the total that the court awarded, the 600 and some thousand, because what the court did is it totaled the medical bills and the future meds, and then cut it all in half. And
right.
then
was there any emotional distress sort of multiplier?
No, that was a
It's just
separate.
straight math.
That's a
Okay.
separate $1 million
Okay.
for the special damages, if you will. So, you could do the math in your decision, or you could opine that the inclusion of the select specialty bills was improper for lack of foundation, and send it back for revision of the judgment consistent with that opinion. I think that's easy, either way.
All right.
Oh, so I'm at 4 minutes, and I'm going to sit down if you'll allow me.
I appreciate that, and I appreciate you. Mr. Abney.
Thank you.
May it please the court, my name is David Abney. Pardon me, I'm here today with Tom Ryan and Sarah Ryan representing Terry Fadley. My colleague across the aisle referred to me as Bodney. There is a very distinguished attorney called David Bodney, but my name is Abney. So if I get credit or blame, I might as well do it under my own name.
Yeah, harmless error, right?
As usual, there are great questions from the panel today. And comments too. Yes, you do have to view this through the lens of the statute, and the lens of the statute is that subsection Q that defines what an enterprise is and refers to any group of persons associated in fact. And here we do have an association in fact. If you did take that unusual hypothetical and say, well, you hired somebody separate to come in and sit, well, if they're there at the hospital, the only way this hospital is giving care is through people that come there to give care, doctors, nurses, therapists, aides, whatever it might be. So if they're permitting somebody to give care, then the hospital could be considered, they could be considered part of the enterprise for the hospital. It really is a question of fact.
How does that jive with the hypothetical of the independent transporter or the independently hired person to babysit? Those two, how does that come in?
The only way that a person could be giving care at that hospital is if they're permitted to give care at the hospital. The hospital doesn't have any people of its own. It has a staff that it has brought in to provide care, doctors, nurses, aides, attendants, everybody down to the gender. So if you bring somebody in and permit them to give care to a patient, then that's part of the enterprise. They're associated, in fact, with giving care.
So and this is implicit in what you're saying, but reading between the lines of what you're saying is that Mr. Workin's hypothetical where a transport company, an independent transport company, brings a patient to the hospital door and somewhere in transit drops the patient, that is not associated with the enterprise because they're not providing the care inside of the enterprises or inside the hospital's facility? Is that what you're saying?
Well, you're skating to the edge of the factual universe, but even on that edge, I think there could be considered to be an enterprise if they are associated, in fact, with providing the care. I mean, if we're wrong about this interpretation of the statute, although it seems to be a very plain language kind of interpretation for a statute that specifically identifies within itself in subpart O of 46-455, specifically says a civil action authorized by this section is remedial. You don't see that very often. We don't have to, as judges and lawyers, come up and say, well, this is a remedial statute. The legislature is saying this is a remedial statute. There's no question about it. It should be interpreted as broadly as possible to provide the relief that it is providing. And it's a statute that the legislature regularly amends. In fact, I was getting prepared for argument. I noticed there was an amendment in 2022. Very minor things, but in subpart B, they changed permitted to allowed.
So what I hear is that if this net casts broadly, maybe broadly in the sense that it's encompassing matters that seem like they might be overbroad, that would be a function of the statute.
Yes.
Am I hearing you right on that?
Yes, and it's not casting broadly, too broadly. It's casting, the idea is to remedy a very terrible situation where vulnerable adults are by definition not able to take care of themselves. They're at these hospitals and other facilities. They're depending upon the people that are giving them care, including the hospital that's in charge of it all, to make sure that they get the care they need, that they're not subject to abuse and neglect. And she was. She came in fairly good health for a person of her age and medical condition. You know, she could walk, she could void on her own, she could get to the bathroom. She was in fairly good condition. By the time she left, she was a wreck. And the trial judge determined, after very carefully going through this, having the bench trial and over 200 findings of fact, that it was the fault of this enterprise for what happened to her. An enterprise being broadly defined.
So, Mr. Abney, did the trial court apply the proper test for apparent or ostensible agency?
Yes, I believe it did.
It did.
Yeah, and it's a very broad definition and a very broad approach in the law.
Can you give me the case so we can start from a point and then we can move on from there that you're relying on?
Well,
Meek?
how
about this? Would you concede that there's a difference between respondent superior and apparent agency? Those are different things?
Yeah, they're related, but, they're certainly. And apparent agency being ostensible agency.
Those are different things?
They're related, but I think they are. That's why, we slice it a little bit differently.
Are they different doctrines of derivative liability?
Yes, but they're related, very closely related, if I may say that.
Okay, well, let's talk about, what is the test for, let's start with apparent agency, as set forth by this court again and again. Do you know what the elements are?
It's basically that you allow someone to be held out as your agent or representative, leading somebody to believe that is a fact, and therefore you have created an apparent or ostensible agency. And here, where the enterprise only operates through its doctors, and Terry Fadley had no choice at all. She didn't choose where she was going to go, number one. She didn't choose any of these healthcare providers. She didn't choose the doctors, the nurses, the aides, anybody. She couldn't bring in her own people. So these people are there. To her, they appeared to be, naturally enough, part of the hospital staff. And indeed, as my colleague today said, they aren't staff. So we have these two doctors. Plus, don't forget, please, while we talk about these two doctors, there are other people that are providing care as part of this enterprise. Nurses, therapists, and other people who are in charge of making sure she's getting the care that she needs.
Fair enough, and the way it was framed to us, this is a derivative liability case. At least that's what I would call it in commercial litigation, which is you have two doctors that mess up, and you're trying to bring them under one roof with one of two things: common law agency principles or the definition of APSA. Is that correct?
I think we are going on different paths, right next to each other and waving, but not quite communicating. APSA is a separate theory of liability. All you have to do is you show that there's an enterprise that...
It's your only theory of liability.
No, there's two. Well, and then there's this ostensible agency theory going on at the same time.
To what claim? It's just floating out there.
No, if you're...
Is there a negligence claim?
Well, if Encompass has ostensible agents that are doing bad things, Encompass is vicariously liable. If Encompass is an enterprise with these doctors, nurses, therapists, and other people who are doing bad things, it's liable under APSA. So you've got ostensible agency liability and APSA liability. And that's the way it was framed in the conclusions of law.
So you're... All right, I thought this was a one count. There was initially a negligence claim and that was dropped. Are you saying now that APSA is not the only claim here?
Well, no. Well, yes. Well,
apparent agency, untethered to anything, is meaningless. It's got to be in some...
What's the claim?
Negligence. What's the claim? I mean...
Well, I'm describing the conclusions of law. This is how the Superior Court, at the end of the trial, this long trial, going through all these facts, this is how the Superior Court explained his reasoning. Okay, you're liable on ostensible agency. 1, 2, you're liable under APSA. That's how the court analyzed the situation.
Yeah, I mean, I think the way I read it, and I think you have to read it this way because, again, if I'm wrong, I would concede. There's only one claim here. So if there's only one claim, then he's either using apparent agency to get the doctors into the same unit of defendant, and then he sort of says, and I still have the enterprise. But so I want to be clear on this. There is a separate negligence claim that was tried, and there was a theory pressed on agency liability separate and apart from APSA. Yes or no?
No. But,
okay, let's go.
Well, having said that, if I could back up just a little bit to Rule 1, where we all start to try to do things in an expeditious, proper, justice-giving manner. This is how the trial court analyzed at the end, in Index of Record 535. He went through ostensible agency and said, there's liability on Encompass on the theory of ostensible agency. And then he talked about APSA and said there's liability on Encompass through APSA. I am happy to rest on APSA and say there's liability.
Well, listen, it's before us as it's before us. If a trial court can say at the end, I'm going to drop in a negligence claim, that's new to me.
No.
Let's keep going. So we had talked about apparent agency, and you're right, that's estoppel-based in sort of components.
Yeah, in fact, it's agency. When I was looking at Black's Law Dictionary last night, I thought I'd just look up ostensible agency to, get my feet under the ground, see what Brian Garner had to say about that.
Okay.
And it referred me to agency by estoppel. That's what this is actually called.
Right. Well, apparent agency and ostensible agency, right, that's estoppel-based. What is respondent superior? Is that estoppel-based?
I feel like I'm in law school. I think it is, in a sense, yes.
Okay. Let's say it's not. Let's say it's premised upon the relationship between master and servant.
Yes.
And you know this much better than I. You're certainly the pro on torts. But does that matter that these independent theories of liability are anchored or premised in completely different doctrines? One is anchored in estoppel. You told me this, I relied on it. The other is respondent superior, master servant. I understand that your word initially was related. I guess the law is related, and everything in tort is related. But are you telling me that that's one big theory? And there's no difference between those two?
No. What I'm saying is that if you look at Index of Record 535, Findings of Fact, Conclusions of Law, the trial judge at the end of the trial analyzed it this way. I believe there's ostensible agency here, and therefore Encompass is liable. I also believe, separately, that there is absolute liability, that Encompass is part of an enterprise with the two doctors and with everybody else who is providing care, and therefore there's liability under APSA. In the end, what I'm most worried about, besides making sure we get the law right, is to make sure my client comes out with the victory that she won after a very hard-fought battle, including this long bench trial. And what she won was under APSA, and she won under ostensible agency. If ostensible agency is thrown out of the lifeboat, that's fine with me, as long as we don't lose sight of APSA, because there is liability under APSA. There was an enterprise. These doctors were in on it, the nurses, therapists, caregivers, they were in on it. Encompass is considered to be a person, as Judge Perkins was talking about, under ARS Section 1215, which broadly defines person for all Arizona statutes as including associations, corporations, as well as natural people.
So, Mr. Abney, if we're talking about ostensible or apparent agency, and the very first requirement of ostensible agency is some sort of representation or action that causes the person to think that this person is an agent of a master, what are we to make of the disclaimer that or the waiver that the admission form that your client signed?
Fascinating admission form, and I urge the court to take a look at it. They attached it, the other side attached it on pages 94 and 95 of their appendix to the opening brief, I believe. It doesn't list these doctors. You will hunt forever to find their names. They're not there. It was signed before she even met the doctors.
Can you give me a case for that proposition that, because I saw that ambiguity argument, and it had sort of two parts. One was the word agent never appears. And the other one was they're not named. So can you give me a case that hasn't been depublished that finds what you're asking us to find?
I guess the closest would be Darner and the cases that follow that when you're presented with a boilerplate contract of this kind, then you're supposed to take a look at all the circumstances to try to figure out what it means. One of the circumstances, the doctors aren't even listed in this form, number one. Number two, they're not specifically described in this form. And number three, she hadn't even met these doctors when she signed this form coming in. Number four, she was in extreme pain when she got in the hospital, and she didn't really know what she was signing.
Yeah, I didn't see that developed. Capacity, I would have heard, that's an interesting argument, but all I see in your answering brief is... Here, there's no record site, and it says, it is unreasonable to think that through the fog of her intense pain, she read the form and had any inkling, but I don't have any record site. Do you have a record site for that?
It's in the answering brief, and if the court would like, I can provide a letter memo after oral argument, but it's specifically in the record, of course, but the extreme pain was...
All right, but there was no capacity argument.
It's not developed as well as I could because I have to be honest with the court. The record wasn't developed very well. What we have is an inference because she did say she was in extreme pain, and that's cited in the answering brief.
And we're supposed to take that and say she didn't have the ability to read and understand terms? Or?
It's a factor that goes into what you do with this boilerplate contract, which she signed before she met the doctors, which doesn't even list the doctors, and which has such vague language, you'd have to be some sort of legal scholar to try to figure out, well, maybe these doctors fall within it, maybe they don't. Who knows? I mean, it talks about different categories of people. There were employees that she's not disclaiming, and then there's the independent practitioners, I think is the phrase that's used. That are described, but are these people independent practitioners? When they're on staff at the hospital, the only way they can function at the hospital is because of the nurses, the therapists, and all the other people that provide them with everything that they need, including drugs and everything else that they're using. Anybody in her position would think that these doctors and nurses and everybody else were staff members. What else are you going to think? And staff members of what? The hospital. It's the hospital giving you the care through all these people named and unnamed that you deal with as a patient. So, Yeah, I think ostensible agency works here. I think that she was led to believe, by inference if nothing else, that they were the ostensible agents of the hospital. And certainly the trial court, after going through this whole process, came to that conclusion. But as I said before, my brief for this client is to try to make sure that her victory is preserved.
Oh, I understand.
And the way that APSA
We're
does
trying
it.
to reach the right conclusion as
Absolutely.
well. So we share that.
Well, I appreciate it. I appreciate the frank discussion. But at the end of the day, when we're done, APSA carries through, and we win.
Yeah, although I'm confused now about this floating I'm going to go back in the record and check. I mean, I'm not sure how that fits in now. But
Well, I came cold to this case, but I read every single item in this darned record, and when I got to item 535, I was so happy because I'd made it to the verdict and the conclusions of law and findings of fact. It's 21 pages long. There's over 200 findings of fact. And the judge actually, and in the conclusions of law, which are also fairly extensive, the judge has a wonderful breakdown of here's why I'm holding for Terry and against Encompass. And the first part is ostensible agency, and he says, okay, and also that Encompass is liable under APSA.
can you address, if my colleagues don't have any questions, the medical bills issue, the select medical bills issue and foundation and the requirements under the law to meet that?
I can try. I think my focus has been on disclaimer the last week or two.
Well, if you hadn't, this agency head fake, I think maybe.
Well, I hope there's no head fake there, but there's a disclaimer thing threw me. But I don't want to distract from the medical bills. I think I laid it out pretty well in the answering brief that there was a representative from the institution that came forward, was a manager, and provided information about the medical bills to the satisfaction of the trial judge. One of those cases where a great deal of deference is given to the trial judge in trying to figure out, well, did I have enough information to decide about the medical bills? So if I can, I'd like to stand on the briefing on that because I think I did a pretty good job on that point at least.
Do you agree with your colleague that, let's say we, as fine as the briefing was, don't agree with your briefing on this point and find that there was not sufficient foundation for the medical bills specific to, I think it was select? What is the proper role of the appellate court at that point? Well,
I bless my colleague for his frankness and cooperativeness. Yes, remand all day long on the medical bills, and we'll provide more information to the trial court, and then we can make sure that it's
I think what your colleague said was that because it's a number in the record that they would actually trust us to do that subtraction.
Oh, I don't like the first part of what he said. The second part of what he said was a remand was okay, and I think I got that right.
He did say that.
Yes, okay, I'll go with the second part. First part's very, very bad. We don't want to do that.
And why is that very, very bad?
Because
my math skills notwithstanding, there are three of us.
If there is some uncertainty here, you might as well let the trial judge sort through the uncertainty. If the trial judge says I was satisfied, uncertainty about the foundation for the medical bills. If the trial judge thought there was enough and came up and agreed on a figure, came up with a figure. And if there's any uncertainty at this court as to whether that was proper or not, please send it back to the trial court and we'll go in and...
So you're saying we would remand to basically reopen the trial for additional evidence?
Yes.
Not for recalculation of damages?
Right.
Can you have any authority for that on an evidentiary error raised on appeal, that's what you do?
All I know is that you folks can do pretty much whatever you want in coming up with a good solution. And I think that this would be an allowable solution.
Yeah, no, I disagree with that job description, as you know.
Well, flattery is always my last weapon.
I need my monopoly instruction guide, which is the law. But, all right, so I won't plug you, I won't ask you questions about the medical bills.
Does anybody want to talk about disclaimer anymore? I had this nice line about Vladimir Putin being able to trying to disclaim facts, and you just can't do it. I'm sorry.
Right.
I won't use that line then.
I would, but again, I'm not sure what this agency thing is now. Other than the court was looking for two paths to find an entity liable under APSA, which is the only claim advanced. One was an agency-based, one was definitional-based, but maybe that's wrong.
No, I don't think the trial court was looking for two avenues. I think the trial court found two avenues as he was going through the facts and the law.
Right.
And I don't think there was any preconception as to where the trial judge wanted to go. He was very meticulous about
Right.
this
The
case.
verb looking there is the second independent reason provided.
Yes.
So that's what I'm saying.
And that'll do the job.
Like the first one was, two separate reasons. Okay.
I think that I have skated. Oh, no, there's a question. Yes, sir. Your Honor, sorry.
How would you define associated in fact? What does that mean? What does associated in fact mean?
I think that not necessarily as a matter of law. We throw out agency, independent contractor, all those labels. In fact, were you working with or doing things in connection with somebody else as far as providing care to a vulnerable adult? I think that's what associated in fact. As a factual matter is, were you doing something to help out in the care, providing care? And if you are, then you're associated in fact. It doesn't matter that you can't be sued.
So what I hear from you then in that is that it's divorced from this notion where I believe Mr. Workin was saying that there needs to be some kind of actual, like a loaded term, like a pre-existing agency. So we need to be shareholders or we need to be employees in order to be associated in fact.
Not at all. Not at all. That would be associated in law.
Okay, so
That's a different kettle of fish.
Okay, so if it doesn't mean that, then it means something else, and what you're saying is it's some sort of concerted action.
Yeah. Are you a caregiver?
Or a concerted goal, I guess.
Right. Well, very simply, did you provide care as a matter of fact to this person or for this person? If you did, you're associated in fact, and you can be part of the enterprise.
And you had referenced before, but you don't believe that can be disclaimed or waived by somebody?
No.
So you're saying this is strict liability?
Once you're associated in fact, and there's an enterprise, yes, there's liability.
Right. So here the hospital or long-term facility will always, it's just a strict liability theory. It doesn't matter whether they did anything, if they provided the building or posted the medical rules, we have strict liability.
Not really. You've got to show that there is APSA abuse and neglect. You've got to show that the enterprise was involved in providing care to the vulnerable adult. And if you can show those elements, which are not strict liability, those are elements of proof,
Right, it's the
then
definition
you
of
get
enterprise.
APSA liability.
Right, it's the definition. I'm not going to bother you longer, but I think it's the definition of enterprise. Once you draw in the facility,
Right.
that's what I'm saying is when the strict liability comes, it doesn't matter what they do, they're liable.
That's pretty much it. And Your Honor, don't worry about my time. You guys are the bosses here, not me.
No. Thank you, sir.
Thank you very much. Thank you.
Thank you.
I'll begin by apologizing to Mr. Abney,
I don't take it.
although I respect both you and Mr. Bodney greatly. In short order, yes, it's a remedial statute, but it cannot be interpreted to create some new liability that was beyond the intent of the legislature. The Braden case would be an example of that, where someone sought to make the state liable. What's the agency test? The Reed case is the primary example, and there are three elements, and inherent in those elements is the belief that someone is an agent, and there are no findings of fact here about the elements of agency. There's no evidence to support the elements of agency. And especially, as I emphasized in my brief, Mrs. Fadley never testified that she believed they were agents. The consent form. The arguments that you just heard about her being in pain and that it's ambiguous, et cetera, that it doesn't name the doctors. I deal with that in detail in my reply brief, and the testimony that is relied upon regarding her pain, that was on a different day. It wasn't on the day of her admission. So that argument falls on its face. The medical bills, the findings, number 212, itemize the bills, and then the court does the math I had highlighted it, conclusion of law, 42, I believe. So adds up the select specialty bills and the smaller bill of another provider. They're about $122,000. But what I was trying to say, Judge Perkins, is that if you do the remand option, it's remand for action consistent with the opinion, which would be an opinion finding that or stating that there was no foundation for the admission of those bills. So you don't get to go
So a
back and do a
recalculation, not an opening of evidence, just a recalculation of them.
Right.
Yeah.
Just, if you want to let the
That's how I
trial
would take in
judge
your
do the
comment.
math, fine. Although I think you're all capable of doing that math.
Are you saying that I don't have it, it says select, and then below it says like M?
D24,
Right.
a different provider.
Okay.
Okay, so you take the select 111,000 out of the equation, and when the court adds that to the future meds and then cuts it all in half, you get this number, which isn't the total judgment, because then the judge awarded another $1 million. So you can do it a couple different ways. You can take either half of the select bills out of that subtotal, or you can just go back and take all of it out and start from scratch without select. So the shot clock is down to 20 seconds. If you have any other questions, I would give those priority.
I think I'm good.
I don't think.
Very fine. Thank you. I appreciate your time and the conversation.
All right, well, with you two, I could stay here all day and talk, and we could just talk about the law, but that's this case, and we will take it under advisement, have a decision out in due course, and with that, we are adjourned.
Thank you.